Hi, I'm Gerard Vadivalu, an attorney in the litigation department at Garlicke Bousfield Inc. Thank you for clicking on this video. I'd like to share with you briefly some insights into the Community Schemes Ombud Service Act. I will refer to this act as the CSOS Act or the Act. Some of the key points that I'll touch on include a brief description of the CSOS Act, some of the court cases that have interpreted the Act, and the impact that the CSOS Act and the cases might have on matters where the relief claimed is one that is contemplated in terms of the Act. You will find that the key question that arises is whether the CSOS Act oust the jurisdiction of our courts. The CSOS Act is a piece of legislation that was promulgated to establish the CSOS Ombud, which is defined in the Act as the Community Schemes Ombud Service. One of the functions of the CSOS Ombud is to provide for a dispute resolution mechanism in community schemes. Community schemes are defined broadly in the CSOS Act and include a body corporate and a homeowners association setting. Let's look at the application of the CSOS Act. Section 38 of the Act provides any person may make an application if such person is a party to or affected materially by a dispute. The CSOS Act goes on to set out what the application itself must contain, but on the question of whether a litigant is obliged to approach the CSOS Ombud, a plain reading of the Act suggests that a litigant has a discretion and is not obliged to do so, by use of the word may in Section 38. Before looking at some of the cases, an important point to keep in mind is that a person may only approach the CSOS Ombud if the relief that they are seeking is one that is contemplated in terms of the Act. You will find the relief set out in Section 39 of the Act, and broadly some of these include financial issues, for instance an order for the payment or repayment of a contribution or any other amount, behavioral issues, for example where particular behavior constitutes a nuisance, scheme governance issues, and issues regarding meetings, management services, and works pertaining to private and common areas. Okay, so what do some of the cases say? Let's look at two of them. Just a disclaimer before we proceed. Please read these judgments in full as this video is quite short and touches on only a fraction of the judgments. The first case is a High Court case in the Western Cape, cited as Coral Island Body Corporate versus Hogue. Briefly, this case concerned an application by a body corporate to the High Court for declaratory and interdictory relief regarding one of its members. One of the main issues being the member effecting alterations without prior approval as per the rules scheme. The court looked at the CSOS Act and the impetus behind its promulgation, but one of the remarks in the judgment at paragraph 10 was as follows: whilst judges and magistrates may not have the power to refuse to hear such cases, they should, in my view, nonetheless use their judicial discretion in respect of costs to discourage the inappropriate resort to the courts in respect of matters that could, and more appropriately should, have been taken to the Community Schemes Ombud Service. The second case is also a High Court case in the Western Cape and is cited as Heathrow Property Holdings and others versus Manhattan Place Body Corporate and others. The court in this case dealt with the question of whether the application was one that should have been dealt with in terms of the dispute resolution procedures established by the CSOS Act and not by the court. The court looked at the object of the CSOS Act, the decision in Coral Island, and the various other cases, so please do read the judgment in full. The court concluded at paragraphs 61 and 62, where disputes pertaining to community schemes such as sectional title schemes fall within the ambit and purview of the CSOS Act, they are in the first instance to be referred to the Ombud for resolution in accordance with the conciliative and adjudicatory processes established by the Act, and a court is not only entitled to decline to entertain such matters as a forum of first instance, but may in fact be obliged to do so, save in exceptional circumstances. What will constitute exceptional circumstances entitling a litigant to approach the High Court directly will have to be determined on a case-by-case basis. The impact that these cases might have on you include the following. Where the relief claimed is one that is contemplated in terms of the Act, and that matter is brought before court instead of the CSOS Ombud at first instance, there might be an adverse course order or a dismissal of the matter, should exceptional circumstances not be found to be present. To conclude, please note that I've only just touched on some of the main points in issue, and every case should be dealt with based on its set of facts. For more information, or should you require assistance with a matter dealing with this topic, please speak to a legal practitioner, and Garlicke Bousfield will be glad to assist. Should you wish to contact me, you may do so on my landline 031 570 5398 or via email on gerard.vadivalu@gb.co.za. Thank you for clicking on this video and for watching it until the end.